Imagine sitting across the kitchen table from someone you love, watching them sign a document they barely understand, trusting a family member or a stranger with complete legal authority over everything they've worked their entire life to build. That moment happens every single day across this country, and far too often, it ends in tragedy. Not because the law is broken, but because nobody told these seniors the truth about what they were actually signing. A power of attorney is one of the most powerful legal documents that can ever carry your name. When it is properly used, it protects you. When it is misused, it can quietly erase everything you own before you even realize something has gone wrong. And the frightening part is that most seniors who sign these documents never receive a clear explanation of what they actually mean in plain language. They get a stack of papers, a pen, and the words, "This just helps us take care of things for you." Those 9 words have cost people their homes, their savings accounts, their independence, and in some cases, their dignity in the final years of their lives. So before anything else, let's talk about what a power of attorney actually is. At its core, it is a legal authorization. You, the principal, are giving another person, called the agent or attorney-in-fact, the legal right to act on your behalf. Depending on how it is written, that agent can manage your bank accounts, sell your real estate, make investment decisions, access your retirement funds, pay your bills, and in some versions, even make medical decisions for you. The document itself does not come with a built-in supervisor. There is no automatic government oversight watching every transaction your agent makes. There is no alarm that goes off when money moves in a direction it shouldn't. It is a document built entirely on trust. And trust, unfortunately, is not always deserved. Now here is the first thing every senior must understand before putting a pen to paper. There are different kinds of power of attorney, and the differences between them are enormous. A general power of attorney gives your agent broad authority over most of your financial affairs, but it typically becomes void if you become incapacitated. That might sound like a safety feature until you realize that the moment you are incapacitated is often exactly when you need someone to manage your affairs. A durable power of attorney, on the other hand, remains in effect even if you lose the ability to make decisions for yourself. This is the version that most estate planners recommend, but it is also the version that carries the most risk if your agent is not trustworthy. A springing power of attorney only activates under specific conditions, usually when a physician certifies that you are no longer capable of managing your own affairs. And a limited or special power of attorney gives your agent authority over one specific task, like selling a car or completing a real estate transaction, and nothing beyond that. The second thing you must understand is who you are choosing and why that choice carries weight that cannot be overstated. Financial elder abuse is one of the most underreported crimes in the world. Studies suggest that the vast majority of financial exploitation cases involving older adults are committed not by strangers, but by people the victim already trusted: family members, friends, neighbors, caregivers, and sometimes even attorneys or financial advisors. The person asking you to sign a power of attorney naming them as your agent might genuinely have your best interests at heart, or they might be counting on your trust to eventually access resources you intended to leave for someone else or keep for yourself. The document does not know the difference. It just grants the authority. Before you name anyone as your agent, ask yourself a set of honest questions. Does this person have a history of financial responsibility? Have they ever borrowed money from you and not repaid it? Do they have debt problems, gambling habits, or a history of making impulsive financial decisions? Are they being pressured by anyone else in the family or in their own life? Are they living in a financial situation where access to your resources would be immediately tempting? These are uncomfortable questions, and most people avoid asking them because they feel like an insult to someone they love. But a few weeks of awkwardness is infinitely better than discovering years later that your savings account has been drained. The third risk that almost nobody talks about is the lack of oversight built into most power of attorney arrangements. Once you sign that document and it becomes effective, your agent generally has no legal obligation to account for their actions to anyone other than you. If you are cognitively declining, that protection is meaningless because you may not even be aware that anything is happening. Courts can intervene if someone files a complaint and proves wrongdoing, but that process takes time, costs money, and often comes only after substantial damage has already been done. By the time a court freezes accounts and investigates, the money may already be gone. One way to build in accountability is to require co-agents. Some people name two agents who must act together, meaning both signatures are required for any major transaction. This is not perfect because it requires both people to cooperate and communicate, but it does create a checkpoint that a single agent acting alone does not have. Another option is to name a separate monitor, someone who receives regular account statements or has the right to review your agent's actions without having any authority of their own. That separation of access and oversight can be surprisingly effective at deterring misuse before it starts. The fourth issue worth understanding is the difference between a power of attorney and a healthcare directive, because these two documents cover very different territory and are often confused with each other. A healthcare power of attorney, sometimes called a healthcare proxy, specifically authorizes your agent to make medical decisions on your behalf if you cannot make them yourself. A living will or advance directive, on the other hand, is a document where you write down your own instructions about the kind of medical care you want or do not want in specific situations. Both of these are important. Neither one replaces the other, and neither one is a substitute for a financial power of attorney, which handles money and property, but generally does not cover medical choices. Many seniors sign one of these documents believing it covers everything, only to discover later that critical decisions in another category were left entirely unaddressed. The fifth risk is the danger of signing a power of attorney under pressure or in a moment of crisis. This happens more often than you might expect. A family member visits, perhaps unexpectedly, and arrives with paperwork already prepared. There is a sense of urgency. The conversation is framed around love and protection. We just want to make sure we can help you. The senior, not wanting to appear suspicious of their own child or grandchild, signs without reading carefully or asking an independent attorney to review the document. In legal terms, a power of attorney signed under undue influence can potentially be challenged in court, but proving undue influence after the fact is difficult, expensive, and emotionally devastating. The far better approach is to insist on time and independent counsel before signing anything. Every senior deserves the right to have their own attorney review any power of attorney document before it is signed. Not the attorney hired by the family member asking for the document. Not the attorney recommended by the person who will benefit from it. Your own attorney, chosen by you, paid by you, who has no relationship with the person being named as agent. If someone pushes back against that request and tries to convince you that an independent review is unnecessary, take that pushback seriously as a warning signal rather than reassurance. There are also specific provisions to watch for in the document itself. Gifting authority is one of the most important. Some power of attorney documents allow your agent to make gifts on your behalf, including gifts to themselves. If your document contains an unrestricted gifting clause, and your agent decides to transfer your savings to their own account while framing it as a gift, they may be operating within the literal language of the document, even though the intent was exploitation. Self-dealing provisions, changes to existing estate plans, and authority to alter beneficiary designations are all areas where language matters enormously and where a single poorly worded clause can create catastrophic results. Revoking a power of attorney is possible, but it requires you to be legally competent at the time of revocation. If your cognitive abilities have declined to the point where someone questions your capacity, revoking a document you previously signed becomes legally complicated. This means the time to be careful is before signing, not after the situation has already deteriorated. There is also a practical step that many people overlook entirely, which is notifying financial institutions directly. Signing a power of attorney document does not automatically alert your bank, your brokerage firm, or your insurance company. Your agent may need to present the document and be formally recognized by each institution individually. Some institutions have their own forms or requirements. Others may refuse to honor an older document that was signed more than a certain number of years ago. Keeping your power of attorney document current and understanding how each of your financial institutions handles these situations gives you far greater control over how and when your agent can act. None of this is meant to suggest that power of attorney documents should be avoided altogether. Used correctly, with the right person named, with proper language in the document, and with whatever oversight measures are appropriate for your situation, a durable power of attorney is one of the most valuable tools available to protect yourself and simplify the lives of the people you love. But the difference between a document that protects you and one that exposes you often comes down to details that most people never examine closely enough. The best time to plan is when you do not need to. When your health is stable, your mind is clear, and you have the luxury of taking your time, asking hard questions, choosing the right professional guidance, and making decisions that reflect your actual wishes rather than someone else's agenda. Do not let urgency, pressure, or the desire to keep peace in a family become the reason you skip the steps that protect everything you have spent a lifetime building. If you found this helpful, please share it with someone you care about, because the information in this video could genuinely make a difference for a family you know.